Hello and welcome to the Charity and Security Network's webinar, Are My Peacebuilding Activities Permissible? This is part of our ongoing Know Your Nonprofit Rights webinar series and will be recorded and posted on our website along with other webinars on relevant topics for nonprofits. Today's webinar will focus on peacebuilding activities and the impact of U.S. law. And as an initial disclaimer, please be aware because of the vagueness that still surrounds the material support prohibition and the court cases on this topic, the information presented here today is the best available at this time and is not either legal advice or a guarantee against any adverse government action. So with that, we will launch into our material, which we think is very interesting and hopefully will be helpful to you. I want to first cite the United States Institute of Peace's definition of peace building, which really emphasizes the breadth of the activities that come under this heading. The U.S. government does not have a formal definition of peace building. It uses the USIP definition, which cites conflict prevention in the sense of preventing or recurring violence, as well as conflict management and post-conflict recovery. In a larger sense, peace building involves a transformation toward more manageable, peaceful relationships and governance structures. The long-term process of addressing root causes and effects, reconciling differences, normalizing relations, and building institutions that can manage conflict without resort to violence. It notes the breadth of the activities that can occur under this heading, including humanitarian relief, protecting human rights, ensuring security, establishing nonviolent modes of resolving conflicts, and providing trauma healing services. So we're talking about a very broad set of activities here. We're delighted to present two experts to give both a legal and practitioner viewpoints on this issue. First, we'll have George Foote, partner at the DC-based law firm Dorsey & Whitney. He's a lawyer with over 40 years of experience and serves as outside general counsel to the U.S. Institute of Peace, the quasi-official organization created by Congress to prevent and resolve international conflict, and also to Peace Tech Lab, Inc. He's a member of the board of directors of the Leadership Crucible, which provides university education for women in South Sudan, and is pro bono counsel to the Wireless History Foundation. He also leads Dorsey's work in the world of telecom regulation and new media. George is a graduate of Georgetown University Law Center. Kimberly Brody Hart of Search for Common Ground will be joining us with the practitioner viewpoint. Since 2014, she has worked in the Global Affairs and Partnerships department there and is now the senior manager of that program. Before going to Search, she worked at Freedom House as Senior Program Associate on Rights and Justice Initiatives. She has a master's degree in human rights from the London School of Economics and Political Science and a bachelor's from Cornell University. The agenda will be a presentation from George with general background on the law, followed by a few questions and answers, and then Kim will provide the practitioner viewpoint, followed by more questions and answers. Please note that on your computer, there is a control panel that should have a tab for questions. And you can type your question in there as we go along. And Andrea Hall will be, Charity and Security Network will be monitoring and reading the questions for us. Due to a technical difficulty we had, George is unable to go on camera with us, but we're happy to hear his voice. As now, George, would you please go ahead and provide the background information on the law? Thank you.
Yes, thank you, Kay. And Kay, thank you very much for the work that you've done ever since the Holder case came down 6 or 7 years ago in organizing our community to figure out what the law is and how best to respond. Your good work and that of the Charity and Security Network has really been a contribution to thinking among the peace building and humanitarian communities. I'm going to start very generally with some comments about this operation in the legal framework, and then we're going to get ever more specific down to some of the threats that our organizations have seen and that we have to deal with. I ought to start with the word of assurance, though. We are focusing pretty technically on what the Supreme Court has said and what the words of the U.S. Code say. In practice, we have not seen a huge amount of threat, and a lot of organizations probably realize that in practice, the practical threat of a prosecution for violating 18 U.S.C. 2339B is not large. Nevertheless, the legal issues are there. Boards of directors want more assurance than lawyers are able to give them, and everybody in the field needs to understand where the gray zone begins, even if the gray zone might be somewhat safe. So with that preliminary view, one more preliminary question or statement, and that is that we're dealing in a world where terrorism is perceived to be a big threat by governments all over the world. The U.S. government spends tens of billions, hundreds of billions of dollars every year on the threat. There's a huge amount of information that's collected. There are sensors of all sorts that collect information. The analytical capabilities of the security agencies are better all the time. What that means is that a lot of information that otherwise might not be assembled is available. And we also have a creative Justice Department, and we'll talk about the Justice Department's prosecution strategies and some of the things they do in a moment. But what we have to realize for people working in the field is that a lot of things that you might think wouldn't be organized, or even if organized and make absolute total benign situation to your view, could be seen by security agencies in a different way. So, having said something trying to be reassuring and something that I know is threatening, let's go into this. What I'm going to talk about is an array of sanctions and foreign terrorist organization statutes. We're going to drill down a little bit into the law, which is most applicable to our organizations, talk about the Holder versus Humanitarian Law Project case, and I'll call that Holder or HLP. We'll talk about DOJ policies for prosecutions, and then with Kim, we'll discuss a little bit about just what to do with all this information and what we know about the world. So the law that we deal with that is the root of our concern these days is 18 U.S.C. 2339A and 2339B. That's capital A and capital B. The definition that's most concerning to us, that is of material support, is found in 2339A, but 2339A addresses acts. It makes it a crime to provide support for a terrorist act. So that is used for prosecuting specific crimes and things that people do. It's 2339B that brings in the cloud of vagueness and the concerns that we have, because 2339B says that it's against the law and you're subject to a penalty of 10 years in prison up to life if somebody dies for providing material support to an organization that is a designated foreign terrorist organization. Let's unpack this a little bit. Under 2339B, the Secretary of State is authorized to designate organizations as foreign terrorist organizations, FTOs. There are about 50 of them. Some of them are familiar names: Hamas, Hezbollah, Al-Qaeda, ISIS. Others have names that you've never heard of and probably never will. But the Secretary of State has pretty much unreviewable authority to designate an organization as an FTO. With that designation, support to that organization brings you within the scope of the statute. The support that we talk about is material support. Hold that thought for 1 second, because there are a couple of other points in statute that we ought to talk about as well, and that is that there is opportunity for civil review of designation of a foreign terrorist organization designation. There's also a provision that we've tried on a couple of different occasions to use but have never been able to, and that is a provision that allows the Secretary of State to give a license to an organization to conduct its training and services without fear of prosecution. If the Secretary of State agrees and the Attorney General concurs, the activities of the organization will be exempt from prosecution. That's nice to know about. We've blunted our sword a couple of times trying to get that license. There's never been one given, and there's not a lot of prospect for it, but hope does spring eternal. So let's talk about the real worry here, and that is material support. Material support is, in many cases, plainly understood, is providing weapons, money, training, transportation to a known terrorist organization. None of us on this call are really concerned with those kind of activities, but let's read what the definition is from 2339A, and I'm quoting here. The term material support or resources means any property, tangible or intangible, or service, including currency or monetary instruments or financial securities, financial services, lodging, training, expert advice or assistance, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, and there are a couple of exceptions. So in that list of horrible things are these little words, training, expert advice, or assistance. And that's where we get to the heart of the issue that we're concerned about. Because we're just not able to tell with a lot of certainty what is training, what is expert advice, or expert assistance. And that was at the heart of the HLP case. Actually, that case went into a couple of other areas that we need to address as well. And that is, excuse me one second. In the Holder case, there was, let me give you the facts of that, and we'll get into what material support means in that context. In Holder, there was an organization, Humanitarian Law Project, that wanted to provide training to known terrorist organizations to help them in peace-building activities. Totally benign. Wanted to help them learn how to petition the United Nations and wanted to teach them how to make peace. It was the Tamil guerrillas and another group as well. That case went on for about 12 years. It went up and down the courts, back and forth, and the ultimate question involved there, from our perspective, was the peace building, the training and material support that Congress meant to prohibit when they passed 2339B. The Supreme Court's answer, spoiler alert, was yes. Any kind of training, in their view, is against the statute. So the court and the parties to the case really wrestled with two parts of the case. One under the First Amendment involving speech, and second under the Fifth Amendment with regard to vagueness. The plaintiffs in the case, HLP, said that the law which criminalizes providing training and assistance was an unconstitutional impingement on freedom of speech. It also said that by describing training and expert assistance, along with this list of other things like explosives and monetary assistance, that the statute failed under the Fifth Amendment for being too vague. The Supreme Court said, nope, the words are plain. All training and expert assistance to any foreign terrorist organization is illegal. Period. Full stop. But that is so shocking to just contemplate in the peace building world. The court delved into it with a little bit more precision. The court distinguished the speech that's given in training under 2339B, that is the forbidden speech, from independent advocacy. The court said, nope, First Amendment is absolute. You can independently advocate the goals of a terrorist organization. You can even be a member of a terrorist organization without violating 2339B. However, any training, and this is where it gets very important, and this is a key thing for all of us, but any training that is done in coordination with or at the direction of the FTO is violating the statute. So the court took the words of Congress and they added a few more wrinkles to it, saying that while speech is protected, if your speech is in coordination with the foreign terrorist organization or at its direction, and in one place they even in the statute, in the opinion, referred to commanded by. So they were talking about speech and training that's done in coordination with, at the direction of, commanded by the FTO. That is what becomes illegal. So that throws the question up to all of us, which is, okay, at what point is speech in coordination with another organization? When is it done at the organization's direction? If you put up a website that has information about how to conduct peace building, and that website is used by an FTO, are you acting in coordination with them? If you know that they want that information, are you in coordination with them? Nobody really knows, and we could do a lot of guessing, but I'm not sure we've really got to an answer there. The court's reasoning on this point was that foreign terrorist organizations are so bad, or actually the reasoning, reading the mind of Congress, was that FTOs are so bad that any contribution that helps them in any way facilitates the goals of that organization. There was some language in the statute that I'll read to you that I think is a little bit hard to follow, but let me read a couple of words from the syllabus of this Holder case. The court said, it's not difficult to conclude, as Congress did, that the taint of their violent activities is so great that working in coordination with them or at their command legitimizes and furthers their terrorist means. Moreover, material support meant to promote peaceable, lawful conduct can be diverted to advance terrorism in multiple ways. Well, we don't have time to go into what Justice Breyer did with that in his dissent, but I would recommend that to anyone who is interested in the policy that the majority of the court found, and that Justice Breyer took apart with pliers in his dissent. However, that's the way the court came out. They also said something else in the case, and let me read that to you as well. This is all the court giving great deference to Congress and even putting a little extra gloss on what Congress did. It said, as to the particular speech plaintiffs, that's HLP, proposed to undertake, it is wholly foreseeable that directly training the PKK, that was the foreign terrorist organization, on how to use international law to resolve disputes would provide that group with information and techniques that it could use as part of a broader strategy to promote terrorism and to threaten, manipulate, and disrupt. Teaching the PKK to petition international bodies for relief could also help the PKK obtain funding it would redirect to its violent activities. Okay, so the message that we take from what the court said in this is that they are really going to, the court leaned very hard into saying any kind of training or assistance, no matter what it is, for a foreign terrorist organization is bad on multiple levels. What we take from that is, therefore, don't provide training, don't provide technical assistance, don't provide advice to the organizations. And everyone in the field then says to anyone saying that, how do you know? What do you do? How do we handle these questions? Because our clients and our colleagues are working in the field where FTOs are present. Maybe the FTOs are even the target of the activity. The key words that we have to remember here are any activities that are directed by or conducted in coordination with the FTO should be avoided, must be avoided, they're illegal. The easy cases here are, don't give weapons, don't give material support. Our advice to clients is not so much as a cup of tea to someone that you know to be a terrorist or an FTO, because even if you don't know if they're an FTO, if you know they're a terrorist, you're going to be swept under the criminality of 2339B. It's okay to preach. It's okay to publish. It's okay to have a website. It's okay to advocate what an organization does. You cannot do it in coordination with or at the direction of the organization. This whole question of what degree of interaction with an organization constitutes coordination or direction that is afoul of the law is something that we all have to wrestle with. And that gets us into what the Department of Justice and how the government looks at this. In the years since 2010, when Holder came down, there have been 500 or 600 cases that have been brought under 2339B, alleging illegal material support for an FTO. Most of those cases are actually pretty easy, and they don't really affect the kind of work that our clients do. Most of them, it was even easy for the government to show coordination with and direction by, because many of the cases involve people who self-radicalize, who publish on social media that they want to go fight with ISIS. They jump on an airplane and they get arrested when they get off the plane in Turkey. That happens over and over again. There are other cases that are closer to it, and there is a whole body of concern now about the so-called preemptive prosecution that justice is doing. The Department of Justice lawyers are creative. They also are policy-driven to the degree that their government wants them to stop terrorism. If they can stop terrorism with prosecutions rather than punish people who conduct terrorist acts, then they believe, and they probably are right, that they are advancing the safety of Americans and people around the world. So the Department of Justice prosecutors using 2339 are looking for stopping terrorism, but they're using other statutes as well. So once they conduct a policy of preemptive prosecution, they're going to use 18 U.S.C. 1001, which is making false statements, because obviously people conducting terrorist activities are going to not fess up to it as soon as they're asked about it by law enforcement. The cases have involved immigration fraud. They've involved financial crimes. So what you have to remember is, as I was saying before, there's so much information about everything that our organizations do that a creative prosecutor who wants to bring a 2339B case might have available raw materials in the form of statements to law enforcement, immigration, financial crimes, other crimes that are combined in these cases. The cases are also brought as conspiracy cases, because conspiracy to violate a law is just as culpable as violating the law itself. Again, you can see from a civil rights perspective a concern about what someone might say to another person that would look like a conspiracy from a law enforcement perspective, when it might just be sympathy for a fellow national of a country. It might just be a desire to protect people in a country. There could be plenty of innocent things that people say that go into building up a case for a conspiracy. A lot of this, I think, goes back to the 1% solution. There was a book that Ron Suskind, an author, wrote back after 9/11, where at that point the government said, if there's a 1% chance that something we do can stop terrorism, then we're going to do it. That, as we can see, clashes with the fundamental constitutional protections, and the Holder versus HLP case sliced it in a way that is pretty uncomfortable for peace-building organizations and actually for a lot of others. So what do you do? The question, we keep coming back to the question of what do you do? Well, I'll tell you what I've done, and then I'm going to open the floor to questions and ask him to jump in here. What I've done for clients is said, okay, let's come up with some guidelines. We don't really know where the boundaries are. We know what our mission is. We know that we want to bring peace and conduct the activities that we know will make a better world, but we also don't want to step over the line of 2339B. So here's just a few pointers that I've given to clients that may or may not be relevant for your organizations, and as Kay says, this is certainly not legal advice, but what I propose to clients who are operating in areas where they know FTOs are present is that they do a few things. First, I've asked them to look for a government partner. If they're working with a government that is recognized by the United States government as having common cause against terrorism, there's more likelihood that the activities are going to be seen as legal by prosecutors. When you're in the field, you've got to control your meetings. You can't let a meeting where you might be providing what we all would understand to be expert advice and training, because you're expert peace builders and humanitarians. You can't let those meetings become classrooms for FTOs, because then you're directly in the crosshairs of the holding an HLP. So control the meetings, know who you're meeting with, understand who gets invited to it. If you have a public meeting, make sure that it's very public and that you're not giving a wink and a nod to try to provide training to an FTO. Document your work. Keep good records. Keep the records. Make sure your people in the field do the documentation as well. Be very careful with your money. Where money is involved, you're getting beyond the question of expert advice and training. It's not really coordination, but a flow of money will be a very quick violation of 2339B. Obviously, when questions come up, make sure that people know that they will seek advice of counsel. In an area where there's confusion, where there's a gray area, if people in the field are operating with guidance from lawyers, they're going to be less likely to be found to have the intention to violate the law that's required to conduct a criminal prosecution. And then ask your people in the field to certify that they're following these guidelines. It goes back to the documentation, and you're building a file on that case. It may not ever be necessary. You hope that it's never looked at, but you are providing for your organization and for your people an awareness or documentation and evidence that they're aware of the law, that they're doing the best thing they can to comply with it, and that they're doing everything they can to avoid anything that would look like a violation. So, Kay, maybe I'll pause here and see if you've got some questions, or if Kim wants to jump in here and see where we go from here.
Thank you very much. It's very helpful. I have one initial question, and then we'll hand it over to Kim. For an organization that's working with other nonprofits, local partners in the field, for example, how far down the chain of organizations where activities may be carried out by a local partner or one of their employees or allies, how far down the chain might an activity take place for which the sponsoring organization or U.S.-based organization be held responsible?
It's going to be hard. It's pretty hard to attribute criminal intent from one independent actor to another. So a U.S.-based organization dealing with partners in the field who have their own employees, contractors, affiliates, what those organizations do is not, in the first instance, going to be something that causes a lot of concern about a criminal violation being charged to the organization in the United States. Having said that, of course, you can see how it'd be possible for a person of a certain mind who intended to get around the statute to try to put other organizations in as a cutout and have the coordination going up and down the line. In that case, the protections of having those independent actors will be lost, and is probably not a very good plan. But I think by and large, given that peace building and humanitarian work is not really being principally targeted by the Department of Justice, the fact that you're dealing with organizations in the field who might commit a violation probably means that the organizations at the top of the chain are not going to have a great risk of exposure.
Oh, thank you. Well, now I'd like to ask Kim Brody-Hart from Search for Common Ground to react to this information based on her extensive experience in the field and running programs. So, Kim?
Thanks so much, Kay and George. And just to say that you guys are the true legal experts here. I'm not a lawyer, but I can tell, some examples from a practitioner side of how we think about these problems as we design projects. So just to give a quick background on Search for Common Ground. Search for Common Ground is one of the largest international peace-building organizations. And we've worked on countering violent extremism in about 50 15 different countries now. For us, it's one stream of many types of violence that we work on as an organization, and one that we've been working on in some countries for up to 10 years. So I think we're still grappling with a lot of the questions that others on this call are also grappling with, but perhaps just because we've been grappling with them for a little bit longer, we might have some comparative lessons to share. In terms of the counter-violent extremism work we do, we kind of have 4 pillars here at Search for Common Ground. One is on prevention of recruitment and participation. One is on disengagement. So how do we encourage folks who have been members to disengage and become, regular civilians? To enable effective state responses to violent extremism and to amplify credible and constructive narratives. And where we see this legal restriction really affecting our thinking and our design is particularly around kind of that second pillar of disengagement, and especially for us, our work around reintegration and rehabilitation of ex-combatants. As George mentioned earlier, working directly with FTOs is really off limits, which from our perspective is a real issue as peacebuilders, because you want to work with all parties to the conflict, but we can't and we don't. But where it becomes more of a gray area is this issue of ex-combatants, and how do you know when somebody's no longer a member of an FTO? What does that look like? And of course, we want to protect our staff and our partners. So I thought, Kay and I chatted a little bit before this webinar, and I thought maybe what would be useful is to give one case study of how we've been thinking about this recently within some of our programming here at Search, but then also happy to answer questions more broadly. So Search has worked on counter-violent extremism in the Sahel for about 5 years, and particularly Niger. And we're implementing a number of different projects in Niger with a variety of different donor funding around countering violent extremism. But recently we had the opportunity to work more specifically and look at the issue of ex-combatants. So earlier this year, we were doing a baseline study for a project that was funded by the Counterterrorism Bureau in Difa, Niger. And the goal there was to understand different community perspectives about the effects of Boko Haram and violent extremism within communities. At that time, as we were sort of designing this baseline assessment, Niger announced their amnesty program for members of Boko Haram, which allowed ex-combatants or current combatants to turn themselves in exchange for amnesty. So we got permission from the Interior Ministry and the governor of Difa to talk to these ex-combatants and understand their motives. So folks who were in camps and who had given themselves up, so that we could understand really what was motivating them in order to design some of our prevention type work. And I think this is a little bit of a simpler case, because in this case we were really just looking to talk to people and to understand what was going on, but we still want to make sure that we were legally protected and our staff were legally protected. So we went back to the State Department, in this case our donor. They thought it was a great idea. They liked the opportunity. That as long as we weren't training or giving any benefit, it was okay to have discussions with these folks who were demobilizing from Boko Haram. Our legal counsel agreed, and so we moved forward and were able to interview 25 people who were ex-combatants, including former fighters, and then folks who played like assistance and support roles. So that's like a more straightforward case. But then this led into some other streams of work that we wanted to design around, particularly how do we work around demobilization with former members of Boko Haram directly. So not just interviewing them, but how do we actually work with them? And we started the process of designing a program that would focus on kind of 3 different groups. The first, volunteer defectors via the amnesty program who were in camps. Second, ex-combatants who were in prison who had been arrested. And third, the communities that would be welcoming people as they reintegrated. And so this became a lot trickier for Search pretty quickly, and really required a lot of dedicated thinking on how to ensure that we were compliant with the law. So the biggest challenge here is that in Niger, there's no legal framework or legal status that formally pardons members of the group if they defect via the amnesty program or are arrested and serve time. So this is kind of unusual for folks who work in the peacebuilding field. A lot of times when there's an amnesty process or a demobilization process or a peace process, legal frameworks are created that state, if you go through XYZ steps, you are pardoned or you are just a regular criminal, but you are no longer a member of this group. This didn't happen in Niger. It hasn't happened yet. But frankly, in a lot of the countries where we work and where other folks online work that have governance challenges, I think this will become a challenge more and more. So this lack of domestic legal clarity made a lot of donors reluctant to engage on the issue because they were concerned, like, if we worked with someone who had been in prison and served their term, how could we affirmatively say that they're no longer a member of Boko Haram? However, there are other donors who said that no matter what, like, these people are coming back into society, this process is in place, the train's left the station. So how do we work on reintegration and rehabilitation in a responsible way? And that's kind of where Surge found itself thinking about these questions really deeply in Niger. As implementers, we approached the U.S. government, even though that wasn't the donor that we were seeking funding from, for guidance, and we worked with independent legal counsel. And in terms of the U.S. agencies, they were really excited about the idea, but reluctant to give us concrete guidance, which isn't that surprising at the end of the day. But then we worked with our board of directors here at Search to identify 2 leading legal firms that would give us pro bono review on the issue and provide guidance directly to us. And so we had one firm who was doing the major review, and then a second firm that was providing like backup secondary review because, as I mentioned, it's a pretty concerning issue. So they reviewed every aspect of our program design, and just to give you guys an idea of some of the questions that they asked us, they had questions around Search's policy more broadly, around terrorism, but also what types of activities were being carried out. Are we giving any monetary benefits, for example, per diems or honorariums? Could there be any risks of anything being provided that could in turn be used to benefit Boko Haram? Like, are we giving them, curricula around effective communication strategies that could be used for recruitment? What mitigation steps could be used to reduce risk? And are there steps that we can use to confirm that these individuals have broken ranks with Boko Haram? So how do we take people out of the category of Boko Haram members and in the category of former members, but now civilians? And so we worked with them really hand in hand, and their recommendations fed into our project design. And so some of the ways they did that included additional training and guidance to our own staff. So what I would say for anybody here who works for an NGO that has local offices and just staff around the world is just that this is a really thorny issue, and one that even lawyers have a hard time parsing through, much less, a staff member or a field staff member who maybe has never even heard of material support laws. And what we, have worked on is how do we actually train our staff so that they understand exactly what they can and can't do and exactly what the steps are in line with our own policies and the legal guidance that we've gotten. And then the second was to integrate specific mitigation steps into the program itself from the start. So, for example, asking program beneficiaries to sign an affirmation or make a formal statement disavowing participation and saying that they want to reintegrate, for example, the folks in prisons who had just kind of been swept up. This is a bare minimum, but it helps them buy into a program and protects us in case there's questions if they formally stated that they're no longer members. And so we estimate that we'll be working with 200 to 250 ex-combatants under this project. But what I would say, and in line with what George mentioned, is that for us, it's been really important along the process to include the government of Niger and have their full support and buy-in. If we work closely with partner governments and work closely with our own governments, then we can carefully ensure that everything is acceptable to both and that we're being transparent from the start. So just quickly to run through a few big takeaways from us. Again, this is just one example. We work on these types of issues in other countries as well, is that each of these is really case by case. So in this case, Niger didn't have a legal framework, and that became particularly thorny. In other countries, there are different thorny issues. And one big lesson I think that Search learned early on was not to trust the donor to be your legal advisor, especially if your donor is not a U.S. donor, but even if it is, we've gotten we've heard a lot of statements from different donor agencies that are frankly just not correct about the legal implications around material support, even from very senior folks within the U.S. government who just fundamentally are giving the wrong advice. We've also heard things from senior level people like, it's not our job to keep you out of prison, which is scary. And so the onus is really on us as implementers to coordinate and work with those folks, but to get our own legal counsel. And I know a lot of folks here come from NGOs and don't have huge budgets for legal counsel. We're the same way. What I would say is, in our experience, law firms have really been willing to jump in and provide pro bono support, which has just been really helpful to us. So so far for us, it's been ask and you shall receive in terms of legal advice, which has just been fantastic to get such good counsel for search. Another thing I would say is, from our experience, is to start thinking about these issues before you even get into program design, starting with initial donor conversations, capture planning, like the very first steps. It extends the design process a lot longer than it might be otherwise. But for us, you know, it's been really helpful to think about it very early on in terms of who we can engage, what that looks like, creating buy-in, and just being really clear from the start, also within our own teams. The third is to document everything, like George said, and be super clear about what our strategy is, how we plan to comply with the law, and then regularly updating that with how we are complying with the law. And then the last, as I mentioned a little bit earlier, was just really that emphasis on training. So we've, you know, revised our counterterrorism policy multiple times here at Search to continue to evolve as this legal thinking is evolving. We just did another update recently. And then just not assuming that any of your staff know this law and really supporting them as they seek to implement work like this. So there's just a few takeaways that we've had here at Search. I know George is the real expert, and probably a lot of you have questions for him, but always happy to chat with folks either in this venue or offline about some of the more specifics around design.
Hey, thanks very much, Kim. I know we have some questions I'd like to put to George and Kim. Andrea, do you want to read the first one?
Sure. The first question is regarding George's statement about the Secretary of State license. George, you mentioned that it had never been given, and this individual would like to know, did you mean that it had never been given to USIP or to any organization or individual? And can anyone apply for that license, even if they're a non-US based organization?
As far as I know, and I'm pretty sure about this, it's never been given to anybody. I will confess that I've struck out twice. I don't know how many people have asked for them. The provision is a tag added on to the statute. Some people think it was put in just to preserve constitutionality and some abstruse legal reasoning. But it was added to statute, and it says that you won't be prosecuted if you get the license from the Secretary of State. The official word from the Secretary of State, from the legal advisor a few years ago, was they just are not interested in creating a licensing regime. If you were to establish a precedent of providing licenses, what you would do would be to bring into the application for the license all of the questions that were involved in the Holder case, and the State Department told us that they just weren't ready to put the resources to doing that, and they said, go away. The Department of Justice may or may not be more inclined to accept that. They're, after all, the ones who have to conduct prosecutions. And as you can see from the 500 or 600 cases they brought, they really are not going after the kind of organizations that would be looking for the license in the first place. So that's a long answer to say that no, none have ever been given. And yes, anybody can ask for it. But recent years' experiences has suggested that's not a very useful approach. However, there may be some opportunity to do that by one or more organizations in the future. So time will tell. Thanks.
The next question is, how does the provision in 2339 that allows states to give licenses to organizations to exempt them from prosecution impact the ability of state to support various programs? Are they able to exempt their own funding from this requirement?
I don't know. And that's a question that I've asked people at Justice in the past when I was trying to find some way to avoid prosecutions. There's a degree of informality among the agencies where there's a level of understanding that governmental actions are not going to be prosecuted. It's not legally tidy. It's a little messy in terms of application across governmental and non-governmental actors. But I don't know how they've worked it out internally, but there certainly has never been a prosecution of anybody in government by the Department of Justice for violating the material support provision.
I would just add, this is Kay again, that after the Humanitarian Law Project decision, on 2 occasions, groups of nonprofits, peacebuilding experts, former diplomats petitioned both Secretary of State Clinton and then Kerry to use this exemption power. It's notable that the power is limited to non-tangible forms of support, not financial support, not food, clothing, materials, kinds of things, but to the communications, essentially, and we thought that this would be a good fit. And again, they declined to do it because it appeared they were concerned about abuse of any kind of general policy or exemption that they might put out there, and then not wanting the headache of having to make decisions about individual applications. So that's where it stands for now, but the statute is there, and the opportunity remains either for groups or single organizations in the future. I have a question about the international impact of this is a U.S. law, but it applies to activities that take place, many of them outside the U.S., and it has what's called extraterritorial jurisdiction provisions. And George, if you could comment on that, and how that works and what the impact of that might be for organizations outside the U.S. who have funding or staff or board members, et cetera, from the U.S.
Sure. I think as an operating principle, all organizations should be concerned about this law being applied to them, whether they are U.S., whether they are based in the U.S., whether they have staff in the U.S., whether they have no connection at all with the United States. Because this is one of many laws that the Congress has passed that specifically includes extraterritorial jurisdiction, and they reach out in a long-arm statute way for lawyers who are listening, that they look for that there's given to the prosecutors a whole kit bag of tools to say there is jurisdiction in the United States. A big part of it comes through the banking system. So much of the world's trade flows through the American banking system that has been used as the basis for claiming jurisdiction. So without getting into the fine points of whether this will hold up or not, I think operating plans by any organization has to be that when Congress says a law will have extraterritorial jurisdiction, there's going to be an avenue for prosecutors to find a way to prosecute a violation of this statute by someone outside the United States.
And Kate, just to add to that previous question about State Department funding, and you mentioned an important advocacy initiative. I'm not sure if other folks on the line were involved in that or have done advocacy around this issue in particular. You know, one other thing that we've advocated for and others in our community have advocated for is just more transparency and more training. And understanding that the State Department lawyers don't want to provide legal advice, but at the same time, there's a do no harm component if the U.S. could be supporting a grant that could ultimately then lead to prosecution of one of their partners or recipients or subrecipients. And so we've pushed, for example, that the calls for proposals should specifically state, you know, which laws apply and how, because right now they don't even mention this law. And, you know, up to training of subrecipients on, you know, some of the kind of framework things that George mentioned. So it's a real issue right now. If you're a youth-led organization working, you know, in Niamey, Niger, you probably don't know what the material support law is. You won't know it exists if you read a call for proposals from the State Department. You don't know how to comply with it, and you probably don't have access to legal advice that, you know, is relevant to U.S. law. And so all of that's a problem, and it creates a do no harm risk, in my opinion, for donors to recipients. So it's something that we've advocated for and others have, but hopefully something we can all continue to advocate for.
Kate, if I could jump in, Kim is absolutely right about that. Our government could do a lot better at giving at least heads up to organizations about this. I think that the reluctance to do it is not only because they don't want to give legal advice, but it's also a very fuzzy statutory area. And I think there is a sense among certainly the folks at State Department and even among people at DOJ that a lot of the organizations who are most attentive to this, who pay most attention to it, will never be subjects of prosecution anyway. I don't think anybody at Justice would relish the thought of bringing a lawsuit against Search for Common Ground for its peace-building activities, despite the authority under Holder. So I think all of that goes to, as Kim was saying, it throws a lot of the burden back to the organizations to pay attention on their own, to put the policies in place, and to make sure that people are aware, their people in the field are aware of the law.
Oh. Do we have any more questions from the participants?
Yeah, we have a couple more. One person says, I am with Impact 2030 trying to engage the private sector in peace initiative in Colombia. Some of these activities may involve ex-combatants. Is this something that they should worry about in friends, de-risking and potential issues with what George talked about?
The answer is yes. That the law is pretty clear. If you deal with FARC or the ELN in Colombia, both of which are on the FTO list, you are in the gray zone. You're in a dangerous area. You know, you get to the point Kim was describing, dealing with ex-combatants. You don't really have people carrying cards that say my membership in FARC expired on September 25th, 2016. And so it's a very gray area. I think the practical answer in those cases is that you take a risk that person will cease to be an ex-combatant, that the person that you're dealing with will commit a terrorist act in the future, and that web of information that we were talking about earlier will come back to haunt you. So anyone dealing with in the Colombia peace process, and you know, USIP was involved in that. We were very concerned about who we dealt with, how we dealt with them, their status at the time. So I think everything that we've said today is advice to anyone who goes into Colombia to deal with the peace process there.
We have one more question right now. It says, de-radicalization process is key to counter-violent extremism in many parts of the world. Such processes require conversation with the youth that are suspected to be violent by religious leaders. In this case, what measures should be in place?
Everything that we talked about as far as guidelines and as far as taking care and vetting should be in place. You know, I think taking off the lawyer hat for a second, the whole question of de-radicalization is and countering violent extremism in places is one that organizations can make a tremendous contribution. Dealing with individuals, that is a person who you might be able to say or to document or to establish to your level of comfort, in fact, is no longer a member of Al-Qaeda or an adherent of ISIS and wants to become a reintegrated person in society. I think dealing with people takes you not well, but sort of beyond the reach of the gray zone of 2339B, which talks about providing material support to organizations. And if you're dealing with an individual who is not acting for that organization and who you can document to your own satisfaction, is not a member of the organization or going back to the organization, even if they're going back to the organization to de-radicalize the entire universe of ISIS fighters, that's a violation. That's a violation. But dealing with a single person, you might have some grounds to say this is not providing material support to an organization. But at every point, it is a fact by a case-by-case basis, and it's in the danger zone. So good luck to anyone who wants to do it.
Yeah, and just to echo George's point earlier about like having your public events be very public and having your private meetings be very careful, I think that's been a practice that Search has used as well in terms of if we're having private meetings or we have program beneficiaries who are specific individuals, we do terrorist checks on all of them. We use LexisNexis for our platform. They check a number of others, but there's other platforms to do it. And every payment that we make goes through the check. Every individual that was receiving funds from Search goes through the check, and we really do try and be very careful about that. And then when we're doing things in public, in places where there is a high risk of recruitment, just like he said, being very public, you know, it's a mobile cinema screening, anybody can come and go as they please, and trying to be, just protect ourselves in that way. But it is really hard. You know, if you're working in Northeast Nigeria, you can't guarantee that every single person you ever encounter in any of your programming, whether it's health or peacebuilding or education, is never going to be part of an extremist group. And I think it's a real challenge for our field, and something that the advocacy that Charity and Security Network's doing is really critical, because technically none of us are ever completely safe unless we only work in countries where there are no terrorists, right? And those don't exist as far as I know.
I'd like to jump in here and remind folks that earlier this year we published an analysis on permissible peacebuilding activities, very much with George's help, that is based on statements that the U.S. government made in the Humanitarian Law Project in their brief to the Supreme Court, and in an oral argument by Elena Kagan, who was then arguing the case as Solicitor General for the government and now is a justice on the court. And as we poured through the transcripts in the brief, we found quite a few statements made about things the U.S. government considers to be permissible, either that they gave as examples or in response to questions from the justices. So there, as George noted, independent advocacy advancing the goals of a terrorist organization is protected speech, which seems bizarre that you can't work with them to take them away from their not violent ends, but at some point that'll have to be a policy and legal shift to make that change. But for the time being, it's not necessary to screen everyone who enters the door in a meeting that's open to the public to make sure nobody belongs to Boko Haram or another group. There are many, many things that can be done, even under the law as it is. So I encourage you to check Permissible Peacebuilding on the Charity and Security Network website to get the details of that information. And at this point, I'd like to ask George and then Kim to give us any closing thoughts.
I think we've pretty much covered the field. My closing thought maybe is where I began. This is an area of very confusing law. The law is vague. The concerns that we have for our colleagues and clients are real. But I think that the management of organizations that are conducting peace building should have a measure of comfort that the Department of Justice really is not going after enterprises like the ones we're talking about, that those prosecutions are probably not going to happen. And what we're doing is trying to give as much assurance to our clients and our friends and our colleagues as possible about ways that they can avoid even getting into the gray zone where these issues might happen. So the council is to remain attentive, to follow the guidelines that Kim and I were talking about, to create your own, to be very careful, but to keep doing peace building and help making the world a safer place.
Thanks, George. Just from my end, quickly, we're all still learning and still thinking about this from the NGO world. And so I would just encourage folks on the line and members of the Charity and Security Network, or those who aren't members, to keep sharing what your strategies are, what guidance you have internally, problems as they come up, and keep pushing policymakers to really to recognize this as a problem and to think about it in an early and often way. So thanks to Kay and to Andrea for creating that platform and just all of us to keep using it and keep sharing information so we can all comply with this law as much as possible.
Thank you very much, and thank you to everyone for listening in. And within the next few days, you can check our website for this will be posted so that you can listen to it again, or feel free to share it with your colleagues. And thank you very much again, and keep that peace building work going.